Good morning to everyone at today's public hearing of the Prosecutor Vetting Commission. My name is Christopher Lehman, and I'm chairperson of the commission and declare this session to be open. Our commission is established under Law 252 on the external evaluation of judges and prosecutors. Under Article 22, paragraph 13 of that law, it provides that this commission will assess candidates for the Superior Council of Prosecutors Discipline and Ethics Board according to the procedures and criteria regulated by Law 26 of 2022 on the measures related to selection of candidates for the position of members in the self-administration bodies of the prosecutors. Our hearing is also being conducted under the Commission's Rules of Procedures for Evaluations under Law 26 of 2022. The subject of today's hearing is Corneliu Popescu, a candidate for the Superior Council of Prosecutors Discipline and Ethics Board. Mr. Popescu, good morning. Let me introduce you to the other members of our commission, starting from my far right, Nadezhda Hryptievsky. Next to her, Ermantas Mikalonis. To my immediate right, Virginia Mararu, the vice chairperson of the commission. To my far left, Cornel Lebedinsky, and to my immediate left, Saskia DeVries. The commission is also assisted by members of our secretariat. This hearing is open to the public and members of the media. The hearing will be conducted in Romanian and English with simultaneous translation. Accordingly, I advise you and everyone else to speak slowly in answering questions to make sure the translation is accurate. The proceedings are being recorded, and the recordings of the Commission's public hearings are posted to our website within 3 days after the hearing. Mr. Popescu, during the hearing, one or more members of the Commission may ask questions to you. Please answer them truthfully and completely. Your explanations are important to the Commission in evaluating your financial and ethical integrity. In formulating our questions, we take into account your privacy as well as the privacy of your close persons. So to that extent, we'll leave out unnecessary details with regards to ID numbers, street addresses, bank account numbers, and that kind of thing. For your protection in answering the questions, we would advise you to also do the same. At the end of the hearing, we'll provide you with additional time to make a closing statement. I'll start briefly by reviewing the evaluation process for this candidate. The Commission initiated its evaluation process on the 22nd of December 2023 by notifying you by email and asking you to complete and return our ethics questionnaire and financial disclosure form. The candidate returned the completed questionnaire and declarations on the 29th of December 2023. As part of the evaluation of the subject's ethical and financial integrity, the Commission also obtained information from other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open source information. The Commission assesses the information it obtains from these sources for relevance and reliability. The Commission also sent you 5 rounds of questions on 24 July of this year, 13th of September of 2024, the 5th of November 2024, the 18th of November 2024, and the 27th of November 2024, and you responded to all of those. On November, I don't have the exact date of the notice of hearing, but I believe it was within the time provided by the statute. The Commission invited you to attend today's hearing. At that time, we notified you of the specific topics to be addressed at the hearing. Mr. Popescu, thank you again for appearing today. I will begin with a few questions to you, and again, I ask you to respond in a complete and truthful manner. First, just let me ask if you wish to make any additions or corrections to any of the answers that you have provided to the Commission in our request to you for information.
No, I tried to provide full answers.
Thank you. And the answers that you provided in the 5-year declaration and the ethics questionnaire that you returned on the 29th of December in 2023. Do those remain accurate as of today, the date of the hearing?
Da, consider că da.
Yes, I believe so.
Thank you. At this point, I will give the floor to my colleague Nadia Hriptievski, who will follow up with additional questions.
Bună ziua, domnul Popescu.
Good morning, Mr. Popescu.
Puteți să vă scoateți căștile că vom vorbi.
To make sure you're comfortable, you can take your headset off because this conversation will be now mostly in Romanian. And when our colleagues will have a question to ask in English, then you will be given the possibility to put them on first. As you have been notified, we will address today a couple of subjects, several of them. And the first one has to do with the purchase of those two apartments that you are the owner of. I will read out certain facts, and then that'll be followed by questions regarding each of them. So at the end of every issue, you will have the possibility to add anything that you think was not addressed. Between 2007 and 2018, you've been at that period of time the owner of a 3-room apartment with a total area of 105.9 square meters in Chișinău municipality, in one of the districts of Chișinău. On the 28th of December, you sold this apartment for a contractual price of 675,000 lei, 34,600 euros. On the same day, you've purchased from your father a 2-room apartment with a total area of 98 square meters in Chișinău too. In Chișinău municipality, it's only in a different city district. You've purchased this apartment for the contractual price of 667,535 euros. That is about 34,000 euros. And on the 10th of March 2020, you also became the owner, following an inheritance execution from your grandmother. You inherited a 1-room apartment with a total area of 49.8 square meters. That was in the same building, actually right next to the 2-room apartment. In the written communication with the Commission, to make it more easier for you to understand, that's around 2:9. You've explained that since the moment that you purchased and until the 31st of December 2022, those apartments, both of those apartments, to make it more convenient, I will be speaking of them as the 2-room apartment and the 1-room apartment. So both of them have been used as residential places for your family that consisted of you and 4 other family members and your grandmother. And also you have confirmed that both apartments are one whole asset at this moment in time. As an opening was created, 2 meters by 1 meter, there was an opening in the walls. Is this right, or is anything you'd like to clarify? It is correct, except that the apartment, the one that is in Botanica City District, doesn't have 2 rooms. I stated it's a 3-room apartment, and there's a layout that I've made available to the Commission too. It consists of 2 bedrooms and a living, same as for the Ciocana City District, 2 bedrooms and a living room. Thank you for this clarification. On the 31st of January 2017, your father entered into an investment agreement with the company X Factor Limited Liability Company. And there was an agreement for the construction of an apartment in a building that was under construction, that the company was building, and there is an agreement for we'll call it the 3-room apartment, the one that you are the owner of currently. On the same day, your grandmother signed a similar contract for a 1-room apartment. You represented your grandmother on the basis of a power of attorney. Is that correct? I guess it is. Now, I can't remember the power of attorney, but I think that's what happened. Did you sign those agreements with your father at the same time, the both of you together? I think so. Why did you represent your grandmother? Because she was of a rather advanced age. She was around 80 years old, and it was hard for her to move around across the town. But your father is an attorney, right? And he was one at that time, yes. And he did not represent her, so you were physically there. Yes, I was. Those were two different assets, both you and your father. Is that right? Yes. According to the investment agreement for the three-room apartment, the initial price that was there as at 31st of January, that was 38,800 euros, that is 832,554 Moldovan lei, which means 400 euros per square meter. According to the other investment agreement for the one-room apartment, the initial price of the apartment was 20,400 euros. That is about 438,102 lei, which is about 400 euros per square meters. According to an answer provided by the Chisinau Court from the Râșcani district of 26 May 2015, an answer to Rise Moldova journalist, by decision of Chisinau Municipal Council number 5/33 of the 3rd of June 2016, the Râșcani District Court was provided a land plot of 0.605 hectares, so rented out to it for it to build a residential block of apartments for the employees of the Râșcani District Court and of the Constitutional Court. Thanks or following the public procurement procedures carried out by that court, the X-Factor company developer was selected as the one to perform the construction works. According to that same letter, the employees of the Râșcani District Court and of the Constitutional Court, according to the agreement with the developer X-Factor, they were to be sold apartments by X-Factor for a preferential price. And there are two categories of apartments: 360 euros per square meters for apartments on different floors, but the last one, and 300 euros per square meters for the last floor apartments. The court was also supposed to pay a particular amount for the rental of that land plot, and the developer built the building on. So the company was to earn a profit out of the sale of those apartments. So part of those apartments were sold for the market price. According to the information from Lara, the market price for apartments with identical features, same area as the one that were invested into by your father and grandmother, in 2017, those prices varied between 513 and 570 euros per square meter. Can you confirm whether your father or grandmother, until 2017, until those investment agreements were entered into, or before that, did any of them work in the Râșcani District Court or at the Constitutional Court in any position? No, none of them worked in any position in those two institutions. Can you explain then how come your father and grandmother managed to obtain prices that were almost preferential? The difference was only 40 euros per square meter. I will try to explain. Well, my grandmother has nothing to do with this. She did not participate in negotiations. She talked to no one. And therefore, as you've mentioned earlier, my father is an attorney. He's been one for more than 40 years. And therefore, in the legal system, he has several acquaintances from different places, lawyers from different companies, working for different companies. So he has negotiated. He has talked about this price. So he asked someone to talk to the director of the company to agree a smaller price compared to the market price. I'm not sure how much that was, 500 or less, the market price that is. And as far as I can remember, one of the conditions imposed by the developer for a smaller price was to pay the entire amount in a short period of time, The other prices were for people who wanted to pay in installments, for instance, over a period of 3 years or 10 years or I don't know how many years. And one of the conditions was this. And in a short time, this was accomplished, and that was the price that was put down in the agreement negotiated by the two parties. So, if I got this right, you've negotiated for your grandmother's apartment? No, I did not negotiate anything. I've only represented her. That was my interest. That apartment, that real estate property was supposed to be mine. But because my father has managed to negotiate a smaller price, I've used that opportunity. What was your role? And since your father negotiated for both apartments as he was an attorney, why did you have to go to sign that agreement on the basis of a power of attorney? Well, we've had a discussion about it. I had an interest in those two apartments being one next to the other. I have a big family, and I realized that nobody will live forever and that my grandmother one day will pass away too. And that's why I took the layouts from that developer. I looked at all of that, the blueprints and everything. As I've also stated in the written answers, my purpose was to sell the Chokan apartment and to buy the Botanica apartment. So I sought this. That's why I went with him together. But in those negotiations, did it matter? Did your position in the prosecutor's office matter at that time? Do you think it mattered? I don't think it mattered because I don't personally know the director of that company. But in your answers, your written answers to the Commission, you stated that perhaps the smaller price was due to collegial relationships because that legal entity that built the building is also supported by lawyers. And according to the information that we have, your father has never represented X factor. Well, I didn't mean that it represented X factor. I would have written that like that if there was any relationship of that kind. But there are other lawyers representing it in different places, and then people know one another. Understood. In the written communication with the Commission, you've also stated that the three-room apartment in 2017, that was bought by your father at your request. Can you explain? Can you provide more clarity about this issue? And can you explain what were the sources for buying that apartment, given everything that was paid in 2017 for this apartment? I will try to explain. In 2015, my youngest daughter was born, so our family was now a family of 5. So we thought that at that time, 5 people in 2 bedrooms, since we had older boys and the youngest girl, that it would be possible for us a few years later. It would be hard to accommodate everyone comfortably. So we started a discussion as to whether we needed maybe to move out of that apartment into a place that was bigger. And indeed, I've asked my father, we were looking in Chisinau what was available, and when I saw that there is such a possibility, all the more so since my grandmother, for a while after she sold her house in the village where she was born and she moved to Chisinau, she had some funds that I was going to take over. That was her wish. And I said, look, I don't need the money, but if you want to invest in an apartment, we can buy these 2 apartments, one next to the other, and you'll be staying with us. And then there will be another bedroom for the boys, for the kids, whoever will be there. So I've asked indeed my father about this. And then I told my grandmother about the second apartment, the one-room apartment, so that, well, in the beginning we already had this idea to have one common asset to be used by all the members of the family. And then upon need, these assets can be separated, divided, and there would be one 3-room apartment and one 1-room apartment. And we were thinking that upon need, the apartment would be sold and the children would get the money. Now, where my father took the money that he's invested at that time, so where he took the money from. A few years earlier, my father had sold another asset, also located in the Botanica city district. There was a real estate that he privatized back in 1996 or 1997, so he had some money from the sale of that, the proceeds. And then in other questions, you've also shown that on his accounts he had some deposits, that he's been depositing funds on certain accounts, and possibly he took some money from somewhere he might have borrowed. I didn't really care about that, because the condition was that at the time that I would sell the Chocana apartment, I would take those proceeds and I would hand it over to him, and we would have an agreement for the Botanica apartment that I would be then registering in my own name. And when my grandmother passed away, there was that will, and then I've taken over the second apartment. I've received it 2 or 3 years after I've registered the first one in my name. So if I got you right, given what you've just said and what you've written to us, your father did not donate that apartment to you, but your father bought it at your request, and then he just sold it to you. Is that right? Yes, precisely. Now, if you take a step-by-step approach and let me know if I got anything wrong. On the 30th of January 2017, your father entered into that investment agreement for the 98 square meters apartment for 39,200 euros. That would be about 884,000 lei. In December 2018, the 28th, you bought this apartment from your father for the price of 667,000 lei, that's about 33,000 euros. This means practically that your father lost 173,000 lei, or about 5,500 euros. That is, if you think of the currency back then. According to the information from the real estate company Lara, in 2018, the market value of such apartments in that building, the values of the prices varied between 998,000 or a million, that's about 50,000 euros, 53,000 euros, which means that your father could have earned at least 300,000 lei or 16,000 euros if he sold it for the market price. Now, my question to you is this 667,000 lei, the 33,000 euros. Is this the actual price that you've paid your father as per the agreement or not? As I've stated in the written answers, this is the actual price. This amount, or maybe a difference of a few hundreds lei, I've taken that from that is the proceeds from the sale of the older apartment. As regards the fact that my father could have earned more out of selling it for the market price, but as I've stated, he had only bought it because I've asked him to do it. It was not about selling it for the market price and earning money out of that, because the intention was to live there, actually. And indeed, there is a price difference if the calculations are right, but I didn't have more money to give him. What I had, and just on that same day, I took it from one place and put it in a different place. That's everything I had. So that was the reasoning. It doesn't mean that my father was supposed to take more money from me. He might not have the entire amount himself, but he could afford, at his age, with his experience, he could afford not to take more money from me. But the difference means that he practically gave you a donation, or did you never have a discussion about it? Did you never, because he invested into that apartment at least more than he has spent the 5,500 euros more than what you gave him. We didn't go into that. We didn't look into the values by the real estate company Lara. There's the cadastral office that establishes prices, and that is the basis for for all people. So we took as a basis that price that was put down by the Territorial Cadastral Office, the Public Services Agency now, as it is currently called, and I didn't have even more money to give him. But you have the investment amount, and that is an agreement signed by your father. Why did you not pay the same amount back to him? So did you have a discussion about paying him less, or the 5,000 euros were just overlooked and not paid attention to? Well, it was not done in any way like that. We've had a discussion, but indeed I only had that amount of money, and he didn't ask for more. He didn't say, give me more, because I invested more. So it felt like a natural thing in a family. Now, speaking of the second apartment, the 49.8 square meters, which was the 30th of January 2017, for that, you signed an agreement representing your grandmother. The amount was 20,400 euros. It is my understanding that this amount, you've mentioned previously that you were not able to provide us any handover takeover documentation regarding that, but it was all paid at once upon the signing of the agreement. You've paid this amount? Yes, as far as I can remember, with the cadastre, when we had it registered, there was also a receipt for that the developer has given us. Now, according to the information collected by the Commission, between 2008 and 2017, your grandmother did not register any taxable income. She's only received her pension, and we've made some calculations for 2017. Although the first installment, although now you have confirmed that actually all the amount was paid at once in January 2017, so the amount can actually be even smaller than that. She's received in that year, for that entire period of time, 155,997 lei, or about 8,000 euros. And the consumer expenditure, the average amounts as per the NBS calculations for that same period, that amounted to 184,000, that is more. So these amounts speak of the fact that she couldn't have made savings on the basis of her pension to make that investment. In the written communication with the Commission, you've indicated that a source of funds of your grandmother's was the fact that the funds were obtained from the sale of the property in the village of Karakushini-Vek, the district of Bricheni, and she's sold land plots. Maybe other sources I did not manage to ask her while she was alive. Can you please provide more clarity, clarify what were those sources that allowed your grandmother to make an investment of 20,400 euros? As I've written also, as I've also answered to the written questions, where she lived before she moved to Chisinau, she had their property with my grandfather. She sold it before she moved in with my parents, and then when the grandfather was no longer around. And the house was in the center of the village. That house was sold before moving to Chisinau. They had some proceeds out of that. When did that happen? It happened in 2013, 2014, I can't remember precisely. But in a different question, you've asked me, or you've stated that she has deposited 10,000 euros on an account and then that money was cashed out. So the money was there even before the 2017 investment. You can already see the source has come out of proceeds following the sale of certain assets. And it wasn't only that house that was sold, but also thanks to or following the division of assets in that village, land was also given to people. So people who were living in the village were given land, and then the value of the land increased, and the land was sold, and those are proceeds. That's where the money came from. Those are the sources. But these sources were supposed to appear to be reported to the tax authorities, but they don't appear there as far as the income or the proceeds of your grandmother are concerned. When it comes to the state tax service, what you report as a source when you pay taxes is only when you've lived for less than 3 years in a particular property. If you've lived for more than 3 years, then when you sell it, you don't pay taxes. What about the land plots? Is it the same? I don't know about the land plots. I'm not sure. I don't know what the law says with regards to that. Your grandmother has also bought a 76.5 square meters apartment in Chisinau municipality. In 2016, that apartment went to your brother. Wasn't that property bought out of the proceeds from the sale of the assets that she sold in that village. I don't know what was the source of that money. How do you know then that when you represented your grandmother in 2017, did you take the 20,400? It was with my father. He had all the money. Did you ask where the money came from? I knew that it was out of the sale of that property. I did not ask questions. I knew that there's been a discussion about this matter, that you wanted to give us some money as inheritance. I didn't want to take the money because you're going to spend the money. So it turns out that when the need emerged to buy property, well, but you are working as prosecutor for many years now, and anything you'd accept in your favor, you were supposed to report anyway. And you need to have some certainty, but 20,000 euros is an amount, it's not something insignificant, and your grandmother was retired. Where did the money come from then? I understand, but you perhaps knew that there was some other investment in another real estate.
In my family, I'm not acting as a prosecutor. This was in the family, I did not get the money or the department from third parties. This was in the family, discussed for years, so I accepted the situation as it was. Thank you. You informed the Commission that currently those two apartments are one entire property and no authorization was needed to join them. Is that right? Yes. By the way, at the cadastre, the 3-room apartment that you're talking about shows as a 2-room apartment, so you should get a clarification. Well, but the plan is available. Also, according to the information that you provided to the Commission, between 2018 to 2022, you had some expenses for the renovation and furnishing of those two apartments, and that ranged from 60,000 lei to 160,000 lei. So it was 160,000 in 2021. But in your income declaration for 2021, you did not declare such expenses. Could you please explain? That was the first year now when the declaration provided for the obligation to declare expenses that were bigger than 10 average salaries. I saw this as one of the questions that made reference to a regulation of NIA that amounts that are bigger should be declared. If you look at that, I did not hide these amounts. It's not part of my income. I didn't even know. I didn't even look at the fact that if you spend at least 10 average salaries, you should have to report. I found that out from the question of the Commission, and then I checked. Mr. Popescu is not only in the regulation. The regulation explains how to do it, but this is a provision of law 133 on declaration of assets and personal interests. Dear colleagues, any questions on this topic?
Mr. Popescu, I have could you explain to the Commission where your grandmother has lived starting from 2007?
Starting with 2007, before selling the real estate in Karakusheni district real estate, she lived there, in the house where she lived, until 2013 or 14, I don't remember exactly. Then she moved in with my parents in Chisinau. She was elderly, it was far away, expenses were high, so she moved to Chisinau. Then we we joined these two apartments, so she was living both at her apartment actually, where she had one room, because from one kitchen we made another room, and in another room one of my children was living. So sometimes, summertime, she was spending in my parents' house in Orhei. At wintertime, she was sometimes at my place, sometimes at my parents' place. They're also living in Botanica sector, like 1 kilometer away.
Yes, when she moved to the apartment which was next to your apartment, Did you move in at the same time?
Cred că eu m-am mutat.
I
Cred că m-am mutat inițial eu,
it was
fiindcă
first
încă nu erau
me
gata
moving
toate
it
lucrările
because
în apartamentul ăla.
in the second apartment, not all the works were finished yet.
And I assume that you have to pay service costs for both apartments.
Da, exact.
Yeah.
Yes, exactly.
Is it considered to be one apartment so that you pay just one price for services of the both, or are they separate?
Da. Am înțeles întrebarea.
I understand your
Separat toate
question,
bunurile și toate,
separately
inclusiv toate
for
cheltuielile.
properties, all expenses.
Thank you.
Just a couple questions. When did your grandmother pass away? What year?
În iunie 2019.
June 2019.
And the house in the village that was sold in 2013?
Da.
Can you describe that house? Tell us about it.
Ok.
Okay,
O casă din piatră,
it was made of
putelez, dacă se poate așa, acoperiș, respectiv
limestone blocks,
5 odăi,
roof, 5
bucătărie,
rooms, kitchen.
mobilat, adică
was
mobilat
furnished.
respectiv în stilul anilor respectiv.
Well, but in the
După
style
care
of
avea
those years,
în curtea o grăză,
in the
era
yard,
garajul pentru
she
automobil,
had also a garage for
era
the
o
car.
mică bucătărie
There
de
was a
vară
small
sau,
summer
cum se numesc
kitchen.
altfel,
I don't know how to call it
respectiv
otherwise.
păsări, bucată de grădină și ceva genul ăsta.
Part of a garden, something like that.
And during her working years, what did she do?
Era profesor la școală
She was a teacher at school
până a devenit pensionar.
before retiring.
Thank you. No further questions.
Domnul Popescu, dumneavoastră vreți să adăugați
Mr.
ceva la
Popescu,
acest
would you
subiect
like to
sau
add
trecem
anything
la
to
celălalt?
this issue?
Da,
Can we
nu,
move to the
am-
next one? No, nothing to add.
Celălalt subiect ține de
So, the
procurarea
next topic
automobilului
is
Volvo de
about
către
the purchase of a
fratele
Volvo
dumneavoastră,
car by your brother
de la fratele dumneavoastră
from
în
your
anul
brother
2017.
in 2017.
La 30 mai 2014,
On 30th of May
fratele
2014,
dumneavoastră a
your
înregistrat,
brother
importul
registered
automobilului Volvo
the import
XC90,
of Volvo
modelul
XC90
sau anul
car,
fabricației 2011.
manufactured year
El a
2011.
importat acest
He
automobil din
imported
Germania.
that car from Germany.
Valoarea declarată la vamă a
The
acestui
value declared in
automobil a fost de
customs for that car was
424.000
424,000 lei.
estimativ
That would be
22.400
estimated
euro,
22,400
care
euros.
și dumnealui a achitat
And
taxele de import
he
în sumă
paid
totală de
import duties in a total amount
62.255.000 de lei sau estimativ
62,255 lei or
Ah, e
3,300
corectă
euros. Is that right?
Da, cred că da.
Yes, I think so.
Dumneavoastră cunoașteți cât
Do
efectiv
you
fratele dumneavoastră a
know
plătit
how
pentru
much your brother paid actually for that car in Germany when he bought it?
Păi probabil că este indicat în actele
Well,
de
probably
însoțire automobilului.
the amount that is mentioned in the documentation, 20-something thousand euros.
Pentru că în declarațiile anuale
Because
cu
in
privire
the
la,
annual
uh,
declarations
interese personale și avere, le vom
of
numi
assets and
declarația
personal
anuală
interests,
de taxe. Pentru
we'll
anul
call them annual
2018,
declarations, for 2018,
fratele dumneavoastră a indicat
your
că a
brother
achitat suma de
reported that he paid
438.750
438,750 lei, estimated of 23,000 euros. So, we presume that this is what he paid for the car. Is that right? Correct. In 2018, the car was mine. No, in 2015, when he filed his annual declaration for 2014, that's what he declared. Yes, he declared what he,
Așa.
as it was.
Acum, la 4 iunie 2014,
Now,
el a
on
înregistrat
4th of June
proprietatea
2014,
asupra
he
acestui
registered
automobil deja
his
la
ownership of
autoritățile
this
din
car
Republica Moldova,
with the
corect?
authorities from Moldova, correct? Yes, I think
Și
so.
la 5 iunie 2014,
On
adică
5th of
chiar
June
a doua zi,
2014, that's next day,
a înregistrat un contract de comodat
he
prin care
registered
va da
a
dreptul de a utiliza
bailment agreement,
gratis
bilateral
acest
bailment
automobil,
agreement,
corect?
which allowed you to
Da, eu
use
aveam
that car for
comodat
free.
și celălalt automobil.
Yes, I also had such a
Așa.
bailment
Dumneavoastră
agreement
ați
for his
utilizat
other car.
acest automobil
So
de
you
la 5
used
iunie
this car
2014
since
până
5th
la
of
15
June
septembrie
2014 until
2014 în
15th
bază
of
de
September 2014 under a bailment agreement.
Nu permanent am utilizat.
I
doar la
haven't used it
necesitate am
permanently,
utilizat.
when
Comodatul
only
nu
when
înseamnă
needed,
că
because
automobilul
bailment
ăla
doesn't mean that I just take the car and I do
Doar
whatever I
în
want with it.
necesitate.
Only when needed. Okay.
Și dumneavoastră ați declarat utilizarea
You
acestui
declared the
automobil
use
în
of the
declarații
car
anuale,
in your annual
depuse
declarations
pentru anul
filed for the
2014
years
și
2014 and 2015, correct?
La
Probably.
15 septembrie 2016,
On 15th of September 2016, you bought this car from your brother and signed a sale purchase agreement, correct? Yes. You declared to the Commission that you don't have a copy of that contract, correct?
Nu am, fiindcă nu am
I do
păstrat,
not have, I did
doar
not keep
unde
it.
a fost,
I only know where it took place, but the Public Services Agency might have it. No, the agency doesn't have it because it's past the period that the documents are stored. In the written communication with the Commission, you informed the Commission that to purchase that vehicle, you paid 170,000 lei, that is $10,000 to your estimate. That was 7,600 euros according to the exchange rate. That's the amount that you paid to your brother during the years 2016 to 2020. In the annual declaration for 2016, submitted by your brother, he mentioned the sales price as 10,000 lei or 450 euros. Can you explain the difference between 10,000 lei and 170,000 lei that you reported?
Nu știu dacă pot anume să explic
I don't
asta.
know if I
Faptul
can
este că
actually
eu declarația
explain
de
that.
avere a fratelui
It's
am
just
văzut-o
I
doar
saw
când am
my
primit
brother's
copiile
asset
scanate
declaration
de la
only when I
Comisia de
received
Bine.
scanned copies from the Commission on Friday.
Și am întrebat, posibil că
I
a fost o
asked,
greșeală
maybe
între
it was a
10.000
mistake.
și 10.000 care noi discutam.
10,000 and 10,000
să
as we were
menționez
discussing,
că
and I'd like to mention that from that amount, anyway, no tax was to be paid, so it wasn't an attempt to hide something. The declaration is done in the next year, so it was drafted in April 2017. Maybe he was hasty, it was a mistake that he reported. In all of my declarations, I reported 170,000 lei, as agreed, as...
Acum, dacă ne referim un pic la utilizarea acestui
Speaking of the use of that car, according to the information available to the Commission, this car was imported on 30th of May 2014 by your brother from Germany, and you were with him in the car when it was imported, according to the border police. Is that correct? It wasn't only me, my wife as well, and his daughter. Were you there to help him import that car, or why? The car, as you mentioned, it was purchased in Germany. The documentation was issued sometime in advance, so we believe, in order not to make it just a trip of one person to Germany, we decided for us all to go to Germany for a couple of days, see the city where we had to pick it, and then how did you travel to Germany? By plane. Did your brother import cars before this one? I think no. The others he purchased from companies in Moldova. Why on 5th of June 2014 your brother provided under the bailment agreement, provided you the right to use the car? Since he bought it, didn't he need to use it? As I said, I had this bailment agreement for another car of his from before, because sometimes I needed to drive somewhere, and the rule for police at the time is that you can't drive a car unless having a power of attorney or a bailment agreement. But you, under bailment agreement, you also had your right to use your father's car and your mother's-in-law car. I think my father's car was sold in 2014, about the same time. It was sold later. I don't know if it was later, but the number plate from the car that was sold was moved to this car. We will get there. So why did you need to use, when needed to be able to transfer, if I need to even go abroad somewhere? Between 5th of June 2014 and 15th of September 2016, did your brother use that car? Yes, he did. How often?
Păi era la dumnealui la folosință. Eu luam
It was
mai
his
mult când am
car
plecat
to
cu
use.
scutarea,
Mostly,
Am fost
I took the car when I needed to go
decembrie,
abroad.
mi se pare că
It was a
anul
couple of
respectiv
times.
a fost
It was
anul
December
următor,
that year, February
Serviciu.
next year for work.
Susțineți că acest
But
automobil
if
era la
you
frate și dumneavoastră îl
suppose
utilizați
that
doar când
the car was with your brother and you were using it occasionally, how can you explain why you were buying the casco insurance policies for this car and not your brother?
În asigurările casco pe acest automobil,
The
într-adevăr,
casco
le făceam eu, fiindcă
insurances
așa am
were
convenit,
purchased by me because that's
dar
what we
dacă
agreed on.
Da, am văzut că sunt în
I
copiile
saw
scanate. Este
them in
indicat
the
și
scanned
soția mea
copies.
și
But it also mentions my
fratele în acest
wife and
automobil
my brother
ca utilizator.
as users. But you are the one to pay. You are the ones to
Bun, da,
contract
mare
them,
parte chitam cât
not
e.
brother. Yes, I was the one mostly paying. According to data on
violările traficului,
traffic violations,
încălcări rutiere, doar dumneavoastră aveți încălcări rutiere. în
you were the
această
only one
perioadă,
to
n-aveți
have traffic
încălcare.
violations
Vă duce
during
atât
that
de bine
time.
sau, de fapt,
Your
n-ați
brother
condus
had no
automobilul
traffic
în această
violation.
perioadă și
Is he
ați
such a
condus
good
doar
driver,
dumneavoastră?
or he just didn't drive the car and it was only you?
Câte am văzut în cazierul
From what I see in the contravention record for that car, not all violations are under Popescu Corneliu. There are some of them that haven't been identified, and you believe those are your brothers. I can't affirm that all of them are my brothers, but I'm just saying that it wasn't only me using the car. But who else?
Păi bun, a fost și soția mea la volan, soția dumnealui
It
la
was
volan.
my wife, his wife driving it.
Care au fost indicați în...
The ones mentioned in the insurance policies.
Între 20 martie
Between
2012 și 4 iunie
20
2014,
of March 2012 and 4th of June 2014, you had the right to use, also under a bailment agreement, you had the right to use the Mitsubishi Outlander,
anul fabricație 2008,
manufactured
care
year
era
2008, owned by your father, correct? Yes.
Și acel automobil avea
That
numerele
car
înregistrate.
had the number plate.
Mă scuzați, îți date, dar
Sorry, that's private data, but you mentioned that, or you know what number plate I'm talking about. Yes, I know. Not to disclose personal data.
Acel automobil a fost
That car was sold by your father on 12th of August 2014, correct?
Astea sunt date din
This is data from the register, so that's the date when the car was sold.
Posibil, eu știu doar că numerele
Possibly.
cele s-au
I
utilizat
just know
la
that the
acest
number
automobil.
plate from that car was used for the Volvo car.
Așa ce este întrebarea.
So there's the question.
Iunie
On
2014,
4th of June 2014, your brother registered ownership over this Volvo car.
Schimbați numerele de la
You swapped the number plate from your father's
pe
car
acest automobil nou procurat.
to the new purchased car,
Puteți
right?
explicați de
Yes.
ce sunt astea
Could you
un fel
explain
de nume
why is that
personalizate
sort of a
care
personalized
reprezintă
number
ceva
plate representing
legat de
something?
tatăl dumneavoastră
Eu am
de
lămurit.
dumneavoastră.
Is
Eu
it
am
for your
lămurit
father?
și
For
în
you?
formă scrisă despre
I
faptul
explained
că,
that in writing as well.
Aceste numere la acel
This
moment
number
nu
plate
considerau
at that time was
personalizate.
not
După care am
deemed to
explicat
be
în adresa
personal,
comisiei
customized.
un răspuns care
Then I
provenit
sent
către
the
luna
commission
lunii de
an
la
answer that I
ACP,
received
că ele
from
se
the Public Services
considerau
Agency
numere
1 month ago. It was
la solicitare, cum o să fie ceva de genul acesta. Și
considered to
ele
be
s-au
number plate
solicitat,
on
s-au remis.
demand.
S-a remis
That's how it
primul
was
număr, care
issued.
tot
The
este
first
asemănător
number
cu al
plate
doilea
that
număr, s-a
is
emis
similar
în
to the first one
2003
was
de
issued in
88
2003,
și al doilea număr s-a
and
emis
the
în
second number
2008
plate
sau
was
2009,
issued in
când a fost,
2008 or
solicitarea
2009 when
De aceea eu am
it was
considerat la
on
acel
demand.
moment, am
So I
discutat
believed,
faptul
I
să
discussed
păstrăm
about it.
acest
Let's
număr,
keep
fiind
that number
primul
plate
automobil s-a
because
adoptat cu numele.
the first car was sold
De ce
with
sunt
the
considerat
number
că,
plate,
mai
and
ales că, din câte au prezentat informații
especially
ACP-ul,
since
pentru
the
numele astea
information
s-au achitați
provided
câteva
by
bani,
Public
că nu
Services
poate
Agency,
foarte
some money
mult,
was
dar
paid for the number plate, so not a lot, but still. Microphone, if you can tell Nadia. I can't hear her.
Scuze. Explicațiile pe care dumneavoastră le-ați dat
The
în scris
explanations
și
that
care
you
reies
provided
și
in
din numere
writing
nu au
and that
legătură cu
result
fratele
from this
dumneavoastră.
number plate have no connection with your brother.
Ele au
Exact, nu au nicio legătură cu
Yes,
fratele meu,
no
fiindcă
connection
numele
with my
acestea
brother
erau
because this
al lui
number
taică-meu.
plate was my
De
father's.
ce numele astea au trecut
Then
de la
why did the
automobilul
number plate
taicului pe care
move
dumneavoastră
from your
l-ați
father's
utilizat
car that you were
la
using as well
automobilul care
to
este
your
totuși
brother's
Păi,
car?
dar anterior
What's
acestui
the reason?
moment,
But
până
before that,
mașina din 2008 a fost
the
procurată,
car was purchased in
care spuneți, da, că eu am avut
2008.
dreptul de a mă deplasa cu ea. Deja numerele astea erau.
The number plate was
Și nu o să
already
țin pe el,
there. They
altele.
didn't want to give.
În iunie.
But in
Dar
June,
în iunie vă gândeați să o vindeți?
did you think about selling it in June?
Tatăl dumneavoastră gândea
Was
în
your
iunie să
father
vândă mașina deja?
thinking in June about selling the car? Because it was sold a couple of months later. It was sold 2 months later, according to the data you provided. I don't know what he was thinking about selling or not selling. The idea was moving the number plate to this car because the other one was older.
Fratele dumneavoastră era
Your brother
avea statut de funcționar public când a importat
was a civil servant when
mașina
he
Volvo
imported
în
the
iunie
Volvo car
2014 și când
in
v-a vândut-o dumneavoastră în iunie
June
2016, corect?
2014 and when he sold it to you September 2016, correct? Yes, I think so.
Dumneavoastră ați indicat în răspunsul
And
în
you
care
mentioned in
scris,
your
fratele
answer
a
in the
fost în
in the written
misiune în
communication that
Polonia
he was on a
până în
mission in
2010 și
Poland
în
until
Israel până în
2010 and in
Unde
Israel
a
until
plecat
2014.
în misiune în septembrie sau
Where did he go on mission in September or shortly after September 2016? Italy.
în Italia? Și dumneavoastră ați indicat
And
că
you
probabil
mentioned that
mașina asta a
probably
fost
the
vândută
car
mai
was
ieftin
sold
pentru
cheaper
că el se ducea
because
în acea misiune.
he
Asta
was
este.
going on that
Da,
mission.
exact
Is
așa.
that your answer? Yes, that's exactly my answer.
Totuși, când noi ne
Still,
uităm la prețurile totale,
if we look at the
facem
total
un,
price,
sumar.
making a
Fratele
summary,
dumneavoastră, care
your
era
brother
funcționar public,
who
deci
was
respectiv
a
salariile
civil
de
servant
funcționar public,
and
am
civil
în vedere
servant
un
salaries,
să zicem așa, de persoană cu venituri foarte mari,
it's not a very
a
high
procurat
level
mașina de
paid job.
23.000 de
So
euro
he purchased a
și
23,000
v-a
euros
vândut
car,
sau 438.750
$438,750
în
lei,
2014
in 2014,
și v-a dat-o dumneavoastră
and gave it to you
în bază de comodat,
under bailment
gratis,
agreement
n-a
for free.
avut niciun venit
Didn't earn
timp de 2
any
ani, ca
income
dumneavoastră
for
să
2 years,
utilizați.
so that you could use it.
Și apoi v-a vândut-o
Then he
peste
sold
2
it
ani
to you 2 years later
cu un preț de 170.000
at
de
170,000 lei, which was 7,600 euros, losing almost 60% of what he paid for this, what he invested in 2016. What's the economic rationale of this transaction?
Având în vedere faptul că automobilul deja
Given
de
that the
2 ani
car
era pe
for
teritoriul
2
Republicii Moldova,
years was
noi nu
already
putem
on the
vorbi
territory
despre
of
același
Moldova, we
preț în
can't speak of the
2016
same
decât
price in
prețul de
2016,
piață,
even
dacă se discutăm despre acest
market
fapt, pentru
price,
că el este,
because
scade cu 10-12%
it decreases
anual.
10-12% per year.
Dacă și era undeva, era în jur de 16-18 mii de euro
So it
prețul
was,
acestui automobil.
the price of that car
În plus
was
la aceasta,
17,000,
eu am
18,000
comunicat
euros.
comisiei că
Moreover, I
erau
informed the
câteva
commission that
probleme, unele din
there were
care
some
persistă și în ziua
issues,
de
some of
astăzi la
them
această
still
mașină,
valid,
acest automobil,
still exist
cutie
with
de
the car
viteză.
related to the
Altele
gearbox.
erau, m-am spus,
Others,
erau câteva
as
probleme
I
la
said, it
caroserie,
has
noi
some
puțin am atins-o de un,
chassis
de un careva acolo, obiect.
issues. We
Respectiv,
touched an
dar nu aceasta a fost
object.
de fapt ideea în vânzare.
But
Ideea
that
era
was
că
not the
cei
idea
care
behind selling. The
în
idea was
localitatea unde el
that
urma să
in
plece
the
să
community
să
where we're
lucreze,
supposed to go and work,
nu era necesar automobilul ăsta așa de mare pentru
he
mai ales
didn't
că acolo
need
drumurile
such a
fiind
big car,
în Italia
especially
puțin mai
since
înguste și puțin mai mici.
roads are
Automobilul
rather
odată nu putea
narrow
să
in
le ia, el a
Italy,
hotărât
and
să iei
he
mașina cea
couldn't
mică, să
take
plece.
this car.
Și
He
au
decided to
scos-o
take
tot
the
atunci,
smaller
în
car,
2016 de la
and
Evidența Republica Moldova.
in 2016
Și au
he
plasat-o la
deregistered
altă
it
țară.
from Moldova and
Respectiv,
registered it for use in
în
another
lipsa
country.
necesității s-a discutat
So,
faptul
since
să
he did
rămână
not
mașina
need
asta în
it,
Moldova, dar
there
lui,
was a
la fel,
discussion
trebuiau
about
sume
leaving
de
the car in
bani
Moldova,
pentru
but he
careva
also
sume de
needed
bani
money,
pentru
certain money
bunul acesta, imobil care este.
for the real
Respectiv, i-am
estate.
propus că
So
eu
I
iau mașina, dar
told
mai
him
mult n-ați
I
pot la fel
I could buy, but I will not be able to pay more than a specific amount that we established together, and I will give him the money over a period of time because I didn't have all the money at once. That was the rationale. Moreover,
eu am luat în luat în considerare că
we
suntem
took
în
into
relații de
account
vedere
that
foarte
we
apropiate,
are
suntem
close
doi frați.
relatives. It's
În
only
plus, mai
the
avem și
two of
alte
us,
careva
brothers.
relații
We have some other
interfamiliale. Și am considerat că, uite, asta este.
family relationship. So that's how it was. Mr. Popescu, but when you imported the car was in a very good condition, wasn't it?
Bună, foarte
Good.
bună, nu știu ce.
I don't know very good who could say that, but it was in a good condition
Nu au fost indicate
because
niciun
no
defect.
defects were reported.
Conform
I think it didn't have
informației
defects. According to information provided by you,
între 2014
between 2014 and 2016, between import and selling, there were 2 accidents that affected the state of a car, but these accidents were committed by you, not by your brother.
Unul din accidente a fost
One of
produs de
them
mine,
was committed by me, and it was covered by the insurance, yes. The second accident, well, I had some guilt in both of them, but as I said, it wasn't what affected the price, but the relationship between the two of us. But in practice, it's like he gifted you the car by paying 23,000 for it and getting from you over a 4-year period 7,600 euros. I don't think it's right to say that he gifted it to me. That was an agreement between two brothers. I'm paying you as much as I can and over a longer period of time. That's it. With my salary, I couldn't cover all that. Thank you. Colleagues, any questions? If I may, I would like to ask some questions. Esteemed Mr. Prosecutor Popescu, I have some clarification questions about the number plate that was initially on your father's car and then on your brother's car. The first question is who booked and who requested and who paid to the Public Services Agency to have this number plate moved to another car? Because we know the rule of Public Services Agency, if you have a preference for a number, you have to book it and then pay for it. So who requested that? You, your brother, and who paid for it? I did not file any application or request of it. The number plates were almost identical, only one digit was different. And from the answer from Public Services Agency, was it was one in 2003, one in 2008, and for one of them we had like 400 lei, and for the other one 800 lei, and my father paid for them because he was driving. Thank you. No other questions.
Yes, I would like to ask you, where did your brother work in 2014 when the car was bought?
He was a civil servant working for one of the ministries of the Republic of Moldova, working for the Ministry of Foreign Affairs, namely.
And his living place was abroad at that time in 2014? He worked in Moldova or he worked abroad at that time?
At that time, he was at home, and in 16, when he left, that's when the transaction took place.
And do you know how your brother paid for the car in 2014? It was paid by cash or bank transferring?
I think, well, I can't answer this question because I don't remember, really don't remember, even though we went to pick the car, but it was paid in advance because we only went there to pick it. He had those resources because he has worked abroad officially, first in Poland, then in Israel, where he received significant indemnities.
Do you aware what funds your brother used for purchase the car in 2014?
As I said, before buying this car, he returned from Israel, where he has worked for about 4 years, I think. Before that, he came back from another European country where he worked as well. And besides salaries, he was getting an indemnity, an allowance as provided for by the legislation. I apologize. Such a question. When your brother imported this car in 2014, did he benefit of the law on status of diplomats that they have a discount? I understand your question. No, for that car he did not benefit of it because he benefited from that for another car previously. I have a clarification question as well, Mr. Popescu, about those traffic violations committed using the Volvo vehicle that we're discussing about. You mentioned that not all violations were committed by you when you were driving the car, some of them being unidentified. According to the report, the contravention record sheet, all of them for 2017, they are all identified with your name. But if we accept your position that it was being driven by other persons as well, could you please say, you mentioned in your answer that it was your wife driving it, your brother's wife, or so both? Your wife and your sister-in-law are civil servants? None of them. No, the wife is, but is not a prosecutor. That's what I'm interested in. Then what would be the interest bigger, for a prosecutor or for a civil servant, not to be mentioned in the report, because all contraventions come with a report, and it says in the report who committed it. You know the procedural rules. Whose interest is bigger, not to mention the name of any of the perpetrators? It is possible because the report is only drafted after the person is summoned to the office of the institution, so where the fine of contravention is to be established. If that summoning is not legal, but it happens later on, it can show up in the contravention record sheet, but the person could not, it's possible the person wasn't aware. So whose interest is bigger, the person who is not a civil servant, not a prosecutor, for their name to show, not to show up in the record sheet? Or for a prosecutor, like openly speaking? I can't answer this question because the violations, and recently I had with parking, by the way, nearby the office of the National Institute of Justice, police approached, drafted this contravention report, issued a warning, and that was it. Thank you.
Mr. Popescu, anything to add regarding this issue, or shall we move on to the next one? Nothing to add. We'll be speaking now about something that is related to specifically ethical integrity, and as you've already been informed, as per the notification in writing, we will be speaking about your actions from the point of view of observance of the national law and the Code of Ethics in the case of Iașanu versus Moldova, in the light of the European Court of Human Rights findings. In the judgment of Iașanu versus the Republic of Moldova of the 31st of January 2023, the European Court of Human Rights found a violation of Article 5, Paragraph 3 of the European Convention on Human Rights, having concluded that although the reasons for which pre-trial detention was applied, although they were relevant, those reasons, they were not sufficiently well-founded, not reasoned enough by the evidence in the case file, and that the justification for the applicant's extended detention was not convincingly demonstrated. And in particular, the findings of the ECHR in paragraph 21, 22, 24 are particularly relevant, and I will read them out. The court notes that in applying and extending the applicant's pretrial detention, the domestic courts referred to a number of criteria, such as the risk of flight or reoffending, as well as the risk of interfering with investigation by destroying evidence, collusion with other defendants, or influencing witnesses. The court considers that these factors were in principle relevant. However, the national courts did not indicate the evidence on which they relied to reach their conclusions regarding the severity of the risks involved. The decisions by the domestic court do not indicate that the courts considered such an important factors such as the behavior of the applicant in the period between the initiation of the investigation in 2014 and the applicant's arrest in August 2017 and September 2018, respectively. Indeed, there was no argumentation and no finding that the applicant had attempted in any way way to interfere with the investigation while at liberty over those years when the investigation was conducted. Moving on to paragraph 22 now. Furthermore, the court dismissed the applicant's argument that he had complied with house arrest requirements in January 2018 without thoroughly assessing whether the police was properly informed of his stay in hospital and without having identified the persons involved in the criminal case with whom the applicant had communicated, as claimed by the prosecutor. It is also relevant that, as the applicant stated before the domestic courts, the criminal case had already been referred for trial, and he could meet and communicate with other co-defendants during court hearings. Despite this, it is particularly surprising that the courts relied on this reason to extend the applicant's detention for another 7 months. Finally, having reviewed the domestic court's decisions regarding the applicant's extended deprivation of liberty, the court considers that the reasons given were stereotypical and abstract. The decisions cited the grounds for detention without any attempt to show how they applied concretely to the specific circumstances of the applicant's case. Given these findings of the European Court, can you explain the aspects that you've raised to argue the need to extend pre-trial detention on the 6th of December 2017? When was the first time that you acted out, if I got it right, for the entire duration? That's when you took over representing the case in court, and that was your first request to extend pre-trial detention of Iașanu, is that right? As you mentioned, I've started participating there not at the stage of the criminal investigation, but when it went to court, not when the evidence was being collected. I participated at a stage where the prosecutor already has the duty to introduce the evidence to the court. To the Commission, I've sent, under the note of confidential, the list of 22 witnesses. That's what I said, and that's quite big a number of people to be heard in a criminal case. As a prosecutor, I have the obligation to keep the integrity of these evidence, to make sure that the depositions or the statements made by the witnesses can be properly kept, confirmed, referred to court. If a defendant is at liberty, there is the risk of this evidence being lost. So when I make a request as a prosecutor at the time of judicial review, when I file such a request for a preventive measure to be extended, I do not rely on new facts, but on keeping the integrity or keeping the evidence that was already collected, so that when it goes to court, because the prosecutor, when the case goes to court, the prosecutor already has a list of all the pieces of evidence. Both sides have access to that, and the prosecutor has the obligation to make that list of pieces of evidence available to the court. And for the preservation of the evidence, that's why the preventive measure was extended, and on the basis of the national rules, I've sought that for that measure to be applied against the person that you have named. In fact, all the decisions, and ultimately, it is not the prosecutor. The prosecutor only makes a request to the court, and then it's up to the court to allow it or to reject it. What is more, every ruling, conclusion of the court, as far as I can remember, was also challenged with higher courts that have kept them, upheld them, and have not found any violations as far as the actions of the prosecutor are concerned. The fact that, and I've also underscored that, the court established, in fact, that. The court established that only certain violations is referred to that, having actually considered the detention as legal, that 1 year that the person was in detention was regarded as legal. With regards to the second matter, Speaking of the two police officers who submitted reports, the court established, as far as I know and out of what I read, that the defense hadn't had access to these two witnesses. As a prosecutor, when I file a request to change the preventive measure or to apply a new preventive measure, for instance, one that is more severe or milder, I provide a substantiation for that. And I've mentioned the reports filed by these two investigative officers who have established certain findings that I've explained. Now, the defense explained or stated that they didn't have access to those two witnesses because they claimed they were not brought to court. It is not up to the prosecutor who participates in the examination of a case. It's not up to the prosecutor to allow or not to allow to a process of third parties to be heard to confirm or infirm certain pieces of evidence. I did name them, and I thought that the request that I filed was well-founded. Then the court established that they were supposed to invite to court, but now that is not up to the prosecutor. Allowing those people or not to court is not up to a prosecutor to decide on. In writing, I did my best to explain the details. I don't think I have anything else to add. Understood. Now, on the basis of your written answer and the answer you provided today and what you've just stated, if I got you right, the key reason why you sought the extending the custody, the arrest of Mr. Yashan was to keep the integrity, the statements of the witnesses. That's right. According to the information, to the records in the case file, and according to the European Court decision, you have sought the extension of pre-trial detention, or you rather supported it in court, because that was sought by another prosecutor on the 2nd of February 2018, the 5th of March 2018, the 3rd of April 2018, the 2nd of May 2018, 4th of June 2018, 27th of June 2018, the 3rd of August 2018. So practically that is 7 months. Can you explain, for 7 months, it took you 7 months to deal with the witnesses, and you kept that person in prison because there was no other way for you to ensure the integrity of the statements of the witnesses? I understand the questions. Now, we can look into the records if that's the situation as you see it in the case. In that particular case, there were several defendants, 6 or 7, if I'm not including 6 or 7 defendants. And the case had been initiated by a particular judge. And the first request I participated in, that I have examined in court, before the court, and then when the preventive measure was changed in June and then in February, that was one judge that, after the request was filed by a defendant for the case to be examined in a simplified procedure, as per the Code of the Criminal, an article of the Criminal Code as worded at that time. The judge decides to examine the case in that way for that particular person, so the case was then referred to another judge. So if you pay attention to the decisions, you will see that the family of last name of one of a judge. There's one in December, January, February perhaps, and there's a different name of a different judge in May, June, July of the year 20-something. At the time when the case was disjoined and sent to another judge, all the procedures are taken over from the very beginning. They are restarted. And although even if 50 or witnesses were heard, they have to resume that for every new defendant that requests a separate simplified proceeding. So in that particular case, only for the months from May, June, July, almost every day we've been having court hearings at the Centro Chisinau office, and as far as possible, those witnesses were showing up. Maybe I can't remember how many there were, 30, 40, 50. That is the procedure, and if you look at the materials, you will see there was a judge looking at the case and then another one examining the case. So that's why it took so long. In addition to that, every appeal filed with the Court of Appeals, that is again a time-consuming affair. But that's what had happened. That was the idea was to keep the integrity of evidence and to present that in court. But is this the practice in all cases?
declarațiile martorilor se ia
Usually, the
la
statements of
urmărire
witnesses,
penală.
these are taken during the criminal investigation phase. And in every cases where there are witnesses, is it always that people are kept in preventive or pre-trial detention while the court is examining the statements of those witnesses? I got your question. It's not in all cases that a person is kept in pre-trial detention, but that is the decision of the court. It is up to the court to decide whether there is going to be home arrest, pre-trial detention, or some other preventive measure. I've only communicated that. I have taken over the criminal case, this criminal case, during this judicial court review, and it is not up to the prosecutor to decide what preventive measure shall be applied. It only contributes, as I previously stated. I have the right to request extending the preventive measure for the purposes of a proper conduct of the judicial review, which I thought that I did.
În cazul de față,
In this particular case, Mr. Ieșanu, the criminal investigation against, or rather the criminal proceedings were initiated in 2014, is that right? I can't remember now, I can't remember the specific data in the case file. I've only answered as to my participation in court. But in court, when you are wording, when you are preparing your request, you do look at the conduct of the defendant. We need to have a better understanding. According to the Code of Criminal Procedure, the measure of arrest, of custody, is it an exceptional or ordinary one? I understand, I agree that it is exceptional, but as I've stated, this measure is not applied by prosecutors. But the prosecutor seeks it. Well, the prosecutor seeks it, but the court can dismiss it. And you are seeking this in every case where you have witnesses. Do you always ask for an extension of pre-trial detention? If the person is in pretrial detention, I think I do. If the person is in pretrial detention, if there's a different preventive measure, then upon need. Depending on the crime that one is charged with, depending on whether there is a case of reoffense, and so on and so forth. Given the findings of the European Court, with regards to how you acted in this case, do you think that you acted in full compliance with the requirements of the Code of Ethics of 2016 of the Code of Criminal Procedure with regards to this pretrial detention of Mr. Ieșanu, or do you think there are some issues? Well, now the law is a little bit more liberal in this regard. So it is, there is a possibility for the person not to be in pretrial detention, but in under a different measure. At that time, though, I think that I've acted in due way. But in 2017 and 2018, the provisions regarding the application that do not deprive one of liberty, including other preventive measures, such as bail or releasing one under judicial control, there was also in force, weren't they? But it's not up for me to decide whether one has enough for bail or to be released under other measures. The prosecutor cannot even challenge the decision of the court while the case is in court. Well, then, can you explain what did you mean when you stated that the legislation is more liberal now and perhaps the person could have been out of custody, or maybe what I mean is that now they don't apply arrest or detention as a preventive measure that much. It's not so often to keep people in custody now, as statistically used to be the case back in 2016, 2018. That's what I meant. Do you think that keeping Ieșanu in detention for that longer period of time, do you think that had anything to do with his specific work, given that he was engaged with, there were accusations of tax evasion? That was a person who had significant funds, and he was also quite active in terms of, he was quite engaging in certain activities that not many of those in the governance levels were happy about. Do you think that it had anything to do with Mr. Ieșanu being so long in detention? I'd like to say that I did not pay that much heed to what Mr. Ieșanu was doing, what he was up to, what he was not up to. To me, he was a person who was accused in a criminal case, and there was a preventive measure against him that had somebody before me established. And the fact that he was engaging in certain activities, to be honest, I don't even know what he was up to, what he was doing. Maybe he was involved in some way with some politics. I don't know. I've just seen something on TV when he participated in some TV shows. I found something more about him after he was released. Tax evasion had to do with his work in terms of processing of metals. Is that right? As far as I can remember, he was accumulating metal from the people, and he was paying certain amounts for that. And I remember that the amounts were distorted, was not quite accurate, was misrepresented, and that's what I think served as a basis for the tax evasion. Thank you. Do you have any questions, or shall we move on to the next one? Is there anything that you would like to add? No, that's all from me.
Mr. Popescu, with regards to the Asanu case, we've gone over actions that you took in the case between February and August of 2018. Did you continue to be involved in that case after August of 2018?
No, as far as I can remember, I have not participated in it further after that time.
There was, in August of 2018, there was a second prosecution that was brought against Mr. Asanu related to an illegal fence. Are you familiar with that case?
An illegal offense?
Fence, as in something you put up between your house and the house next door. F-E-N-C-E, that word.
Yes, I am aware of that. I am aware of that criminal case.
Did you have any involvement in that case?
No, that criminal case was not referred by me to court, and it was not even the Office of the Prosecutor General or some other body, the Organized Crime Prosecutor's Office. None of them brought the case to court, but it was the Territorial Prosecutor's Office that brought it to court.
Okay. A minute ago, you answered one of my colleagues' questions by indicating that the responsibility was only of the prosecutor to make a request and that a detention decision is really the responsibility of the judge. But doesn't the prosecutor have a responsibility to make sure that the request that they're making to the judge is legally based, that it's based on laws and not some basis that would violate the law? Isn't there some responsibility for the prosecutor to only put forward in good faith a request to the court that they know to be legally supported?
I absolutely agree with this position. I did not put all the responsibility on the court. I just communicated that it's not up to the prosecutor to apply or not apply a preventive measure at that moment in time. However, as I've communicated, my requests as a prosecutor, they were based on the evidence, on keeping the integrity of evidence, and that was enough for the court to decide to extend that measure.
Thank you. I don't have any further questions on this issue.
Mr. Popescu, anything for you to add regarding this matter? Shall we move to the next one? Nothing to add. Thank you. The next issue has to do with a disciplinary sanction as a reprimand that was applied to you on the basis of a decision of the Superior Council of Prosecutors in 2019. And it's specifically by that decision 1-44 of 2019 of 23rd of May 2019, the Superior Council of Prosecutors has established that you as a prosecutor committed a disciplinary violation, that is, failure to discharge obligations properly, and specifically they've established there was non-compliance with the principle of legality and independence in the exercise of a criminal investigation, which undermined the standards of professional conduct. A summary would be that the SCP has arrived at the conclusion that in exercising the criminal investigation, particular case that was initiated on the 30th of January 2015, that you have made serious procedural errors that you did not correct in court. And the SCP concluded that, for instance, one of the indictment orders that were issued in that case, that they did not comply with the legal requirements and that it contained some abstract formulations not being clear and concrete as required by an article of the Criminal Procedure Code. The SCP has also concluded that the disciplinary sanction imposed on the prosecutor was due to a violation of criminal procedure norms in issuing the indictment order, not because of the solution reached in the criminal case under investigation. The SCP made some reference to the consequences of the disciplinary violation, and namely that the individuals, the persons who were acquitted by final court decision, that they had been in custody in preventive arrest for an extended period of time. Concurrently, the injured party was not provided with effective remedy, effective redress against the actions that limited their legitimate interest, in this case, their property right. The SCP had concluded that all the consequences for the parties in the case, that they were directly related to the errors that you have made and that your actions have affected public trust in the prosecutor's office from the perspective of justice seekers, and as a result that has harmed the image and the prestige of the prosecutor's office. You have challenged the SCP decision, and the Chisinau Court of Appeal annulled the decision of the SCP. However, the Court of Appeal decision was not reasoned. The Superior Council Prosecutors has challenged it with the Supreme Court of Justice, but belatedly, and as a result of that, the Supreme Court of Justice rejected the second appeal, did not look into the merits of the case, because they've stated that it was appealed too late, so it was rejected on the basis of procedure reasons, because the deadline was not observed. The Commission obtained the decision of the Court of Appeal that you have sent us to, but it's a decision that tells you nothing at all. It just upholds something. Can you explain why the Court of Appeal, or what was it? How did you argue your position? And why did you think that the SCP decision was not well-founded? So that we could have a better understanding for the Court of Appeal's decision. Just a short introduction regarding that case. I've initiated a criminal case on the basis of certain facts and events that I was notified about as per the law, and so on and so forth. Now, following, and on the basis of the evidence was collected, the case was sent to court with the indictment order. Now, the Chocana City District Court established that the people, both of them, were not guilty and they were acquitted. Now, we've challenged it with the Chisinau Court of Appeal. And the Chisinau Court of Appeal established that those people were guilty. And the charges that were brought against them were regarded as well-founded, and they were even sentenced to prison. After that, when there was a second appeal against that decision, the Supreme Court of Justice annulled the decision of the Court of Appeal and stated that the decision of the first instance court was all right and that they were to be acquitted. There was no notification from anyone, not from the injured party, not from the people that charges were brought against. Without any notification whatsoever, by its own motion, the prosecutorial inspection takes action and believes or arrives at the conclusion that I am at fault for all of those events. Because, as they've established, this indictment order, according to them, did not meet all the criteria set out in the law. And when I've presented my case, I stated that couldn't have happened because, first of all, one of the people was extradited, and that indictment order has went through the Office of the Prosecutor General because it was a case of extradition. And second of all, the Court of Appeal, 3 judges of the Court of Appeal, when they looked at that case under appeal, they've also established that the charges are clear enough and that those people are going to be convicted. Well, there are other opinions of courts, and that is something normal in a democratic country, and the prosecutor doesn't have the right to comment on that. Now, the case was forwarded to the Ethics and Disciplinary Board for Prosecutors. That commission has unanimously established that I had no fault for what has happened and that I have not violated any procedure. Afterwards, the prosecutorial inspection decided that it disagreed with that decision and it challenged it with the Superior Council of Prosecutors. And then, as you've stated, the SCP has delivered an opinion. They've established that I was to be reprimanded, and I disagreed with that, and I was visibly... I will explain. In Moldova, there are a lot of cases of acquittal in the country for different reasons. That the charges were not good enough, that people did not commit the crime. And my case was the only one in the prosecution service where I was brought changes against disciplinary violence. I was involved in a disciplinary action for acquittal, was the only one. So I went to the Court of Appeal and I explained my case before the judges of the Court of Appeal, and I've explained what were my possibilities. I explained to them my views, and I've also told them the decision of the Ethics Board under the SCP. I've explained that. I was listened to, and the representative of the SCP was also listened to, was heard. And then the court realized, or arrived at the conclusion, that I violated nothing, there was no violation established. And in general, in these cases, from the criminal records, such events should be deleted. For some reason, this remained, though, on the website Magistratul.md, in the prosecutor's page, and in all the prosecution documentation, this case remained until I specifically sought for this to be erased, deleted, and I provided all the documentation from the Supreme Court of Justice and the Court of Appeal for that to happen. And I believe, as I've stated before the Court of Appeal as well, I believe that I have not committed any violation in examining this case, and that was my position.
So didn't you ask for a reasoned decision of the Court of Appeal? I was not interested in that decision because it was favorable to me. Immediately I went and took from the Secretariat of the Court, I filed to the Prosecution Service for it, in order to get a calculation of all the bonuses or allowances that I was deprived of during that disciplinary session. Do you know why the SCP filed it beyond the deadline, even though the decision was unanimous? Why were they late with the appeal? Because from what I read in the decision of the Supreme Court, they were late 1 or 2 days because they waited for it in a physical form, in a hard copy. So there was electronic information about the decision. They did not file it within 30 days or whatever was the day for appeal, but they waited for the hard copy. So they filed the appeal after the second appeal, after they received the hard copy of the decision. I had no connection with filing that second appeal or things. Could you please explain at least what you in the Court of Appeal? Was it related to procedure or substance? Because you also about starting it, because the prosecutor did not notify. No, it wasn't notified by anyone. And there was a violation of procedure. So did you follow this line in the Court of Appeal or the substance? I think probably both. I apologize. It was 4 or 5 years ago. Did you self-represent? Yes, I did represent myself. Thank you. Colleagues, any question to this topic? Would you like to add anything? No. Then let's move to the last topic for today's discussion, and that is the disciplinary procedure and the court findings regarding unauthorized transmission of personal data in 2014. Namely, a decision of a disciplinary board under the SCP of 12 September 2014, you were issued a warning for improper performance of your duties. Namely, your colleagues found that you printed the legal file of one limited company, whose founder and administrator was Citizen X, and you provided that information to a lawyer you knew who provided it in a case in the Court of Appeal. You did not appeal that decision because you, as you mentioned in the written communication with the Commission, you said that I acknowledge that I retrieved that legal entity's file and I transmitted it to a court, which certain information in that personal file was hidden. Could you please explain? Now we're speaking about the same thing. You transmitted that information, that legal file or legal fiche, to a lawyer or to a court. And could you please clarify at whose request did you pass that information? Thank you. Yes. Indeed, I acknowledged that I committed a violation back then because, in the absence of a procedure that I was handling, I retrieved that file of a legal entity. I acknowledged that I was wrong because a colleague asked me, a lawyer, he said, I need some information to provide to Chisinau Court of Appeal. To obtain it in a different way, it would take him at least 2 months. So since we were colleagues, he asked me, could you please check? We checked that information, and I gave him that file that he applied only before the court. He attached it, because that individual who was party to that case saw it, and checked that attorney couldn't have obtained that legal file, especially since at the bottom of the page it said that the person who retrieved the document was my name. Before the disciplinary board, I admitted that I committed that violation. What can I say? I acknowledge that, and that's what took place. But let's clarify, because you said different things in writing, or maybe it was a typo or omission. So you provided it to a lawyer, not to a court, to the lawyer. And that was a friend of yours, an acquaintance, a friend. So he just came and asked you? No, he said that, look, I represent the interests on a civil case in the Chisinau Court of Appeal. A person, an opposite party, does not provide information that we know about. Could you please check it? And I did check. And I was not authorized to do. Well, I was authorized to check any information, but I had no legal ground to do that, procedure or something. So you accessed information without any legal reason, and you processed it. You passed it on without a legal reason. Correct. The same things were found by two decisions of court, one of 29th of October and one of 30th of October, were different. You know that thing? Yes. Yes, I was part of those court hearings. I know there was one, not two. Yes, you sent a copy of one of them, but we found a copy of another one, and they seem to be related to the same deeds. You don't know. You're not aware about the second, but the same, based on the same facts. Yeah, but it was Judge Boyko, sorry, it was a judge. And there was another judge, so you don't know about the other one. Exactly the same acts, and the court found the violation, but did not apply any contravention because the statute of limitation was passed. Is it correct? Correct. Did you have any similar actions after that incident of 2014? No, I haven't, because the disciplinary board warned me about that. Please don't do that in the future. Do you believe that this is a serious enough violation? It was a violation. I admitted it. I don't deny it. Dear colleagues, any questions? I have a clarification question about this. If you know What was the effect of showing that piece of information that you retrieved and gave to your colleague, as you said, of showing it in the court? Did it tip the balance of justice to make it favorable to the client of your colleague? I don't know if it was favorable, but the court found out new things from that file. Namely, that the individual owned a company, a thing that was hidden before that.
So could you clarify, please, what type of information you provided to the lawyer?
Păi uitați-vă, pe un format A4
It's an A4 standard paper.
fișa persoanei
That's
juridice, unde este
like
indicat
the
fondatorul,
fish of the legal entity. It shows who the founder is.
care de fapt era persoana fizică.
The founder was an
Doar
individual.
atât conținut.
That's the only thing that was in there.
Thank you.
Are there any further questions, Nadia?
Dumneavoastră mai aveți la acest subiect ceva de
Nu.
completat?
Do you have anything to add here? No.
I think we are finished with the questionings. Mr. Popescu, I'd like to give you the opportunity if you choose to make any closing statement for the commission.
Da, mersi. De fapt,
Yes, thank you.
în formă scrisă,
I actually prepared it in writing.
folosesc formă scrisă pentru
Also, as state prosecutor, I use documents that I prepare in writing.
Deci, stimați membri ai comisiei,
Esteemed commission
cred că am
members,
fost destul de explicit în toate
I
rundele
hope
de
I was
întrebări,
clear
răspunsuri
enough in all
la
rounds of
procesul dat
questions
de
and
evaluare.
answers during this
În calitate
evaluation
de candidat
process.
în Colegiul
As a
de etică și
candidate to
disciplină de
the
subordonare
Discipline and
SCP.
Ethics
Dorim să
Board under the
menționez,
SCP,
dacă nu a existat
I
nicio
just
cumva
want
intenție
to
de a
mention
extinde
that
sau
there was
prezenta
no
informații
intention to
neveridice
hide or
la
to
orice etapă a
provide
testimoniei,
inaccurate
asigurându-vă de
information
absolut
at any
contrariu.
stage of
Am
the
fost la
evaluation.
fișă
So
solicitare de CP,
I
descris
try
și în ultimul rând
to
interesat de exactitatea și
be
conformitatea
very
datelor
clear
prezentate.
and to provide
Totodată doresc să
correct and
menționez,
accurate data
perioada
at
de
every
15
stage.
ani a
Also, I would
verificării
like
este
to
în
mention
mare.
that the
Pornind
15-year
de la
period of
faptul că
evaluation is a
legislația
long
Republicii Moldova
time
vizând
frame,
declararea de
especially
venituri și proprietăți,
that the
ținând
legislation
continuă
of
ajustare și
Moldova on
modificare,
declaration of
inclusiv
assets and
mecanismele
interest
declarării,
has been
și noi
continuously
de fiecare
adjusted
dată posibil
and amended, including the mechanism of reporting, and I wasn't always able to provide the documents that were asked. The same thing is valid for other legal instruments that Moldova has been developing as an independent country. And I believe that the Commission checked all the information that was provided because looking into the information that the Secretariat of the Commission provided me, I found some wrongful information there, such as Corneliu Popescu traveled as a tourist to London, Prague, Verona, and Paris and others. I would like to inform you that I have never been to the UK or Russian Federation, and even though I was in Italy, I have never visited Verona or Venice. Regarding the ethical aspect of my work, a Romanian saying is that he who doesn't work, well, the only one who doesn't make mistakes is the one who doesn't work. So I hope for a fair evaluation. Thank you.
Mr. Popescu, we thank you for your participation throughout the evaluation process and at the hearing today. The Commission will now deliberate on the matter and issue a decision at the earliest moment, and I declare this hearing to be closed. Thank you.